If you are planning to represent yourself in your restraining order hearing, you should know that you can win. You can represent yourself and win, but you're going to be missing third-party perspective. And in this video, I'm going to be explaining how to deal with that problem, how to get around it and make sure that you get that third-party perspective that you really need, and explaining sort of how it works so that even if you don't have an attorney for your hearing, you don't miss out on having that perspective. My name is Veronica. I'm a restraining order defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you everything that you need to know to fight against your restraining order hearing and win without an attorney. In the course, I explain what the judge is looking for, how to present your evidence, how to point out inconsistencies and what the other side says. There's just one thing sort of missing. Anyway, for the course, you can get your free first class down below, but let's talk about that something that is potentially missing. Okay, the problem is that no matter how smart you are, it is difficult when you are facing a restraining order case, when you get served with this restraining order and you are taken aback by it. There are probably a bunch of things in it that are untrue. When you have a mountain of evidence and you're like, where do I even begin? What can I say? What can I not say? What does the judge want to hear? Like, the other side did so many things wrong. How do I even go through this? It can be very difficult to sort of zoom out and see from a third party's perspective what this situation looks like, what your testimony looks like. But you have what's called the curse of knowledge, right? Like, you know about this whole situation, you know so much. And so it can be very difficult to sort of hone in on what's important, because the judge will not let you sit there for a week or a day or probably not even an hour, and probably a lot less than that, to explain your side of the story. So it can be difficult to see from a third party's perspective, and then many judges will ask questions during the hearing, and sometimes you can be surprised by the judge's questions, and that actually does apply whether you have an attorney or not. Now, the solution here is to have someone review the other side's story. So if you're the respondent, to have them review the petition for restraining order and ask you questions and have you present your evidence. Now, ideally, you do not tell them your side of the story first. You don't want to curse them with your knowledge, right? So you have them read the other side's paperwork, and then you present your side of the case with whatever evidence you have. Now, ideally, you have a time limit. So you want to keep the pressure on yourself, because in court, they're not going to let you just present everything that you want for as long as you want. So you want to keep it realistic. You want to make sure that you emphasize the most important things. And if you set a time limit, that is going to help you hone in on what is actually important. You can also practice your presentation of the evidence in sort of an official way. So in the course, I teach you how to present your evidence, what you need to say to make sure that the judge considers your evidence. So you want to make sure that you present that in an official way. And this is also a good test of how organized you actually are. Like, do you have your text messages in chronological order? Do you have, hopefully, the most important ones, tabbed and ready to go? And more importantly than that, you can gain some valuable perspective. So let's say that you miss something that they wrote in their restraining order. You never address it when you are presenting your side of the case. Well, now the other person can ask you, what about this? You never brought this up. Tell me what happened here. They can also say, wait a second, I don't understand what you said there about that interaction. Like, can you explain that to me again? Did you push the other person or no? Did you hit the other person or no? Are you saying that they hit you first? They can ask you for all those clarifications, and hopefully you can see there the flaws in your testimony. I'm not saying everybody has to do this, but I'm trying to teach you ways that you can be as prepared as possible, because an attorney will do this, right? An attorney will question you and will say, wait a second, what about this? Are you lying here? And they'll sort of cross-examine you when you're giving your side of the story, or say, well, why didn't you do this? Why didn't you do that? So you kind of need somebody like that. So if you have somebody bossy in your life, or someone who will ask you the hard questions, that would be a great person to have do this. Now, obviously, this would be best with an attorney, so you can also try to hire an attorney who would conduct this mini practice session with you. I do offer this service. Actually, I love doing this. I'm sort of playing the judge and asking you questions. And if you want to do that with me, there is a link below to book it. I would say if you want to do this, you should probably either watch a bunch of my YouTube videos or even better, like you actually do take the course, so that when you're presenting your evidence, instead of telling you, okay, well, those text messages are not going to be admissible, like because of XYZ reason, instead of me focusing on that, I'm telling you, hey, I don't think that those are important. I think these other ones that you were focusing on, those were more important. And you didn't answer the question about this, or your explanation of what happened in this sort of physical altercation made it seem like you did start this, or that you use excessive force, and I can give you that feedback that will show you, this is what a judge is looking for. And ahead of time, so that you're not correcting these issues when you are in front of the judge. But many attorneys would probably be willing to help you out with this, and on a limited basis, like via a paid consultation or something, talk to you about the case and do sort of a prep session with you. I hope you found this video helpful. And again, if you're considering representing yourself, I highly recommend that you at least take the free first class in the course. You can see kind of what it's about, get some valuable tips right there, and see if the course is for you. But if you're going to represent yourself, there's a bunch of information there that you need in the course. You need it. You need to know what the judge is looking for, how to present your evidence, how to cross-examine the other side. So I think if you are planning to represent yourself in the restraining order hearing and the results of it is actually important to you, then it is really important that you take a course, whether it's mine or some other course out there. Anyway, if you did find this video helpful, please don't forget to like, subscribe, and ring the bell.